We will certainly allow you, but at the appropriate time. Let's start with, because none of us were judges when the presidential reference was filed, nor any of us had heard the presidential reference at any stage, nor there is any judge in the Supreme Court who's heard it. So you may even wonder on the constitution of this bench. It was placed before the committee as, let's not keep speculating on everything. This Chief Justice has relinquished powers and now matters are decided by the committee. Farooq sir, just 2 seconds, just bear with us. What we did was, one senior member did not want to be part of the bench. 2 others was some way or the other related. It was felt maybe they should not be. So just want to allay that. And since the last time it was heard was 9 members, so we tried to do the same, because sparing a lot of judges also takes time. So now if we will start with the presidential reference, and then we will go through all relevant orders. So Attorney General, can we request you to read, since it's your presidential reference, if you can read the presidential reference?
Sir, I'd just like to point out.
We will go, don't worry.
I just want to point, a tribunal was formed, headed by Justice Shafiur Rahman. And
Farooq Saab.
Okay, sir.
Don't mind, but let him start. Okay. So actually, to be honest, I've not read it.
Okay, okay, sir. Thank you.
So let's read it.
My Lord, this reference comprises of 15 pages.
No, not the facts. What does the President of Pakistan want us to do?
My Lord, if my Lords may kindly turn to order dated 21st of April 2011.
So
that order records the questions which were referred.
So before that, in the presidential reference, it is under which article of the Constitution?
186.
Can you read 186? We do one thing at a time. It's reproduced, I think, in the first page of the presidential reference.
Yes. Clause 1. If at any time the President considers that it is desirable to obtain the opinion of the Supreme Court on any question of law which he considers of public importance, he may refer the question to the Supreme Court for consideration. 2. The Supreme Court shall consider a question so referred and report its opinion on the question to the President.
Okay. Now this is an extraordinary power vesting in the President. And which President had filed this reference?
Sir, President Asif Ali Zardari.
Okay.
On the advice of the federal government, the cabinet.
And what was his tenure in office till?
I believe it was 2008 through 2013.
And after that, how many presidents have come?
2, my Lord.
And none withdrew it?
None of them. So
it's still on our docket?
That's right, ma'am. It's presidential reference number 1 of 2011.
I must regret on behalf of the Supreme Court that it was not listed earlier, because we have a policy now of first in, first out, unless there is some urgency in a particular case. Okay, so would you like to refer to the presidential reference or the order now?
My Lord, I'd like to refer to the order, because that order then captures the questions.
Okay, which order is that?
It's 21st April 2011, 21/4/2011.
21 April.
Isn't there a question in the reference itself?
My Lord, the questions were in the reference also, but
why don't we go to the question of law that was, Mr. Attorney General?
My Lord.
Could we just refer to the question of law raised in the original reference?
My Lord. My Lords, if my Lord may kindly turn to page 16 of the reference.
It finishes at 15.
There is no question.
It finishes at 15. 16 is a summary for the Prime Minister.
These were placed. These were placed subsequently. There was an order dated 13, 14, and 18 there were orders, several orders of 13, 14, and 18 April 2021.
Why don't
2011 and on 21/4.
Why you read the reference?
The I can
read the title of the reference that itself sums up the question. After a reference ka title.
Reference by the President of the Islamic Republic of Pakistan under Article 186 of the Constitution of the Islamic Republic of Pakistan to revisit the case of Zulfikar Ali Bhutto, reported as PLD 1979, Supreme Court,
original file
53, 38.
File separately some questions, because in the reference the questions are not reflecting in any heading.
My lord, if your lordship will allow me, it's a reported matter. The order of this honorable court where the questions were framed.
That was like the questions framed by the court.
Yes, my lord.
We are asking what about the questions which you framed in your reference for the opinion of this court?
That is in the reference.
My lord,
but this honorable court also framed the questions
which were framed in the
This honorable court also framed the question, and it is a reported matter.
I think, Mr. Attorney General, why don't we just read the entire reference?
my lord.
And if there are sort of irrelevant or just factual things, we'll skip those.
Well, what happened was that after
let's now.
The reference was filed, the questions were subsequently forwarded. I'll skip the language of Article 186 from page 1 and then I'll read. After the restoration of judiciary by the present democratic government, all the institutions of the state are adhering to the constitution and constitutional scheme of trichotomy of power. The judiciary in Pakistan is independent and is playing a proactive role in the cases of public importance. However, some important questions of law remain unanswered, and one amongst them is in waiting since long. This is the case of Zulfikar Ali Bhutto, reported as PLD 1979, Supreme Court, page 38, decided in Criminal Appeals number 11, 12 and 13 of 1978, who is the founder of the Constitution of Pakistan, first elected Prime Minister of the country, leader of the Third World, Prime Minister of Non-Aligned Movement, founder of the Islamic Bloc, who took the initiative of introducing nuclear technology in the Muslim world. He was convener of the first Islamic Summit in Pakistan, which attracted unparalleled participation of leaders of the Muslim Ummah. Facts. In pursuance of wide-range conspiracy, Shaheed Zulfikar Ali Bhutto was challened by the Federal Investigation Agency maliciously to face trial for offences under Section 120B, 302, read with Section 109, and 301, and Section 307, read with Section 109 PPC. The trial was conducted by the Lahore High Court in a highly objectionable manner, and he was judicially murdered. I, as the President of the Islamic Republic of Pakistan, in order to uphold the dignity of the court, supremacy of the Constitution and law, feel constrained to refer a few questions of law which are of paramount public importance and remain yet to be finally determined and answered by the Supreme Court of Pakistan. 1. The law of approver and criminal conspiracy is admittedly against the injunctions of Islam. The Holy Prophet, peace be upon him, on the occasion of Hijjatul Wada, pronounced, "Beware, every culprit is responsible for offense committed by him. Beware, the father is not responsible for the offense committed by his son, nor son is answerable for the offense committed by his father." Admittedly, absence of the accused from the scene of occurrence could not at all constitute personal liability. 2. Earlier, no accused had been convicted and sentenced to death solely on the testimony of an approver. The Honorable Supreme Court of Pakistan has again disapproved the testimony of an approver in the case of Mian Muhammad Nawaz Sharif versus State, PLD 2009, Supreme Court 814, and the law continues to be volatile. The testimony of the approver fails to satisfy both the tests in that he is neither reliable nor his testimony is corroborated in material particulars. 3. Intricate questions of public importance are involved in the matter. None is above accountability in Islam, and more so a Qazi. Determination of the question of accountability, or at least a correction of error, amounts to introspective accountability. The democratic system of a country is dependent on the functioning of political parties. Leaders of political parties are repository of public trust and confidence. Their iconic image is an inspirational and motivational force for the followers. In the case of Shaheed Zulfikar Ali Bhutto, this goes without saying that he was the leader who inspired generations. His charismatic leadership remains a role model for the toiling millions of Pakistan and the Third World, and his appeal for downtrodden is transcending through an annals of history. His totally illegal death sentence and his execution at the hand of tyrant dictators with the help of hand-picked judges is a black spot on the democratic face of Pakistan. 4. Whether the Supreme Court was acting within four corners of law while deciding the appeal by a bench, which was not duly constituted after the absence of two honorable members, namely Mr. Justice Wahiduddin Ahmed, who was shown sick, and the bench chose to proceed in his absence, notwithstanding the fact that he was desirous to join the proceedings, and Mr. Justice Kaisar Khan retired during proceedings. The Honorable Court was legally and morally duty-bound to fill the vacancies. 5. In the case in hand, bias in the minds of judges was floating on the face of the record. A bias in the mind of judge results in vitiation of the proceedings. In the celebrated judgment reported as Asif Ali Zardari and another versus the state, PLD 2001, Supreme Court 568, while dilating upon bias, the Honorable Apex Court held as follows, as under C. A judge may have a personal bias towards a party owing to relationship and the like, or he may be personally hostile to a party as a result of events happening either before or during the trial.